This is not speculation. It's not a proposal. And it's not something that might happen later. Just hours ago, the White House officially signed a brand new immigration law. And almost nobody is talking about what it actually changes. If you hold a green card, if you're on an H1B visa, or if you're protected under DACA, this law applies to you right now, not next year. Not when you renew, right now. And here's the part that makes this urgent. The first wave of consequences begins before January 30th. That date is not symbolic. It's a trigger point written directly into the law. After that, certain protections quietly disappear. New obligations take effect, and people who think they're safe could find themselves flagged without warning. Some immigrants will glide through this with no issues at all. Others will be shocked to discover they're suddenly under review, not because they broke the law, but because they didn't realize the rules changed. In the next few minutes, I'm going to walk you through exactly what was signed, who is most exposed, and what you must do before January 30 to protect your status. And I want to be very clear about something right now. This is not about fear, it's about facts. Everything you're about to hear comes directly from the signed legislation and official government guidance released within the last few hours. No rumors, no exaggeration, just the reality of what's now in effect and why waiting or ignoring this could be the most dangerous mistake you make this year. Hi, I'm Sophia. I closely track verified immigration updates from official sources like USCIS and the Department of Homeland Security. And when something this significant happens, timing matters more than opinions. Immigration law doesn't usually change overnight, but when it does, the people who act early stay protected. And the people who don't often find out too late. My goal here is simple, to give you clear, accurate information so you can make smart decisions for yourself and your family, without panic and without confusion. To understand why this law is causing so much concern, you need to understand how different it is from almost everything that came before it. In the past, most immigration changes came through executive orders, internal policy memos, or temporary guidance. Those could be paused, challenged, or quietly reversed. This is not that. What was signed is full legislation passed by Congress and locked into federal law. That distinction matters more than most people realize. It means these changes are not optional. They are not experimental, and they are not limited to future applicants. One of the most important and least discussed aspects of this law is that it applies retroactively. In other words, it doesn't just affect people who apply for a green card, an H1B, or DACA in the future. It applies to people who already hold those statuses today. The rules you followed years ago are no longer the only rules that matter. There are new compliance expectations now, and the government is no longer waiting for something to go wrong before it checks. This law shifts the system from passive oversight to active verification. Instead of reacting to problems, the system now looks for them. That's why people who believe they've done everything right still need to pay attention. This law doesn't assume you're out of compliance, but it does require you to prove that you're not. And that shift alone is what's catching so many people off guard. So let's slow this down and talk about what was actually signed in plain language without legal jargon. The law is officially called the Immigration Status Verification and Accountability Act of 2025, and it was designed around one central idea: continuous accountability. The government now has the technology to track immigration status in real time. And this law creates a unified digital system that connects immigration records, employment data, travel history, and tax compliance into a single verification framework. The law itself is divided into four main parts. One focuses on permanent residents, meaning green card holders. Another focuses on employment-based visas, including H1B. A third addresses humanitarian protections like DACA, and the final section outlines enforcement mechanisms, timelines, and penalties for non-compliance. What's important to understand is that this law doesn't suddenly cancel anyone's status. It doesn't create mass removals. Instead, it creates checkpoints at specific intervals and under specific conditions. Individuals are required to confirm that their status is still valid and that they're meeting all ongoing requirements. If everything checks out, nothing happens. Life continues as normal. But if something doesn't align, missing information, outdated records, unexplained gaps, the system flags the case for review, not punishment, review. That distinction matters. This law is not designed to target people living genuine lives in the United States. It is designed to identify inconsistencies, neglect, and situations where people have quietly fallen out of compliance without realizing it. And that's why January 30 is so critical, because that's when the documentation expectations begin. From that date forward, I didn't know is no longer a shield. The system assumes awareness and the responsibility shifts squarely onto you. So, who exactly does this law affect? The short answer is almost everyone currently inside the U.S. immigration system. But to understand the risk clearly, it helps to break it into the three groups facing the most immediate impact. First are green card holders. If you are a lawful permanent resident, this law introduces new verification obligations that did not exist before, even if you've lived in the United States for many years without issue. Second are H1B visa holders. If you work in the U.S. under an employer-sponsored visa, both your employer's responsibilities and your personal exposure have changed in ways most workers don't realize yet. And third are DACA recipients. While the program itself still exists, the renewal rules are now tighter, less forgiving, and far more sensitive to timing errors. What makes this especially dangerous is that many people in all three groups assume this law doesn't really apply to them because they've never had a problem before. They've renewed successfully. They've traveled without issue. They've worked, paid taxes, and stayed out of trouble. That assumption is exactly where the risk lives. This law doesn't wait for a mistake to happen. It checks for one. And if you're not ready when that check happens, even a small oversight can snowball into months of stress, delays, or loss of work authorization. Before I go any deeper, this is the moment where I want to say something important. If this information is relevant to you or someone you care about, make sure you stay connected here. Immigration updates don't always come with warnings, and missing one detail can cost far more than people expect. Everything I share is based on verified sources, and I'll continue breaking this law down as implementation guidance is released. Now let's get into the group with the largest number of people affected and also the most confusion right now. Green card holders. Because for permanent residents, the shift created by this law is not obvious at first glance, but it is fundamental. Under the old system, once you received your green card, your obligations were relatively straightforward. You were expected to maintain the United States as your primary home, avoid serious criminal issues, report address changes within a certain time frame, and renew your physical card when required. Beyond that, the system mostly relied on trust. Unless something triggered a review like a long trip abroad or a criminal charge, the government generally didn't check in on you. That honor-based approach is now officially over. The new law places every green card holder into what's called an ongoing status verification framework. This means that instead of being reviewed only when something goes wrong, your status is periodically confirmed as a matter of routine. According to the law, every permanent resident will be required to complete a formal verification process at set intervals. This is not optional. It is not a request. It is a legal requirement tied directly to maintaining your status. Here's what that looks like in real life. At regular intervals, currently defined as every 18 months, you'll receive a notice requiring you to verify specific details about your life in the United States. This notice may come by mail through a new USCIS digital portal, or both. When that notice arrives, the clock starts. You'll be expected to confirm your current physical address, your employment or financial situation, your travel history, and your continued intent to maintain permanent residence in the United States. The process itself is designed to be relatively simple for people who are prepared. It's expected to take about 20 minutes online. But preparation is the key word, because if anything you submit doesn't align with existing government records, your case doesn't disappear. It escalates not to deportation, but to administrative review. That's where documentation matters. That's where organization matters. And that's where people who haven't been paying attention can suddenly find themselves under scrutiny they never expected. Let me make this very real with an example, because this is where people usually say, "That won't happen to me." Imagine someone named David. David received his green card several years ago through his employer. He owns a home in the U.S., pays his taxes, and his children attend school here. On paper, David looks exactly like the kind of permanent resident this system is meant to protect. But in 2023, David's company asked him to temporarily work from their London office for 8 months. He didn't think twice about it. His family stayed in the United States. His mortgage payments continued. His life remained centered here. Under the old system, that would have been the end of the story. Under the new law, when David completes his verification and the system detects a continuous 8-month absence from the country, his case is automatically flagged. Not because he did something wrong, but because the system is designed to ask questions when certain thresholds are crossed. Now, David is required to prove that he did not abandon his residency. He needs documentation showing the assignment was temporary, evidence that his home and family remained in the U.S., and records showing continued financial and social ties. If David is organized, the review is resolved quickly. If he isn't, the process can drag on for months. The law doesn't punish David for traveling, it requires him to justify it, and that distinction is everything. This leads directly to one of the most important things you need to understand. What actually triggers a review under this new system? According to preliminary guidance released alongside the law, several specific conditions automatically escalate a verification into a deeper review. A single trip outside the United States lasting more than 180 days is one. Cumulative foreign travel exceeding 240 days within any 12-month period is another. Failure to file U.S. tax returns for any year since obtaining permanent residence is a major red flag. Address discrepancies between your USCIS records and other government databases can also trigger review, even if the mistake was unintentional. Extended gaps in employment without documentation explaining how you supported yourself are another. And here's one that surprises many people. Maintaining substantial financial assets, businesses, or property in your country of origin that could suggest your primary residence is divided. None of these automatically mean you lose your green card, but each one requires explanation. And under this law, explanation means evidence, not verbal assurances. I want to pause here because this is where anxiety tends to spike. Having a flag does not mean your status is revoked. It means your case is looked at more closely. The system is not designed to remove people who are genuinely living permanent lives in the United States. It's designed to identify situations where someone may be using permanent residence as a convenience rather than a commitment. If you've had legitimate reasons for travel, if your financial life is centered here, if your intent to remain in the U.S. is genuine, documentation protects you. What this law eliminates is ambiguity. It removes the benefit of the doubt that existed under the old honor-based system. Now let's talk about timing, because this is where the January 30 deadline becomes extremely relevant. The full digital verification platform will not be fully operational until later in the year. That part is true, but the documentation obligations begin on January 30th. From that date forward, the expectation is that you are maintaining records as if verification could be requested at any time. In other words, the government is giving people a runway to prepare, not a grace period to ignore. Starting January 30th, you should be able to prove your travel history, your tax compliance, your residence, and your ties to the United States without scrambling. This is why preparation now matters far more than reaction later. The smartest thing a green card holder can do right now is create what I call a personal immigration file. One place, digital or physical, where everything connected to your status lies. Tax returns for every year since you became a permanent resident. A simple travel log with dates and reasons for each international trip. Proof of U.S. residence like leases, mortgage statements or utility bills, employment records or proof of financial support, family documentation if your spouse or children live here. This isn't about fear, it's about control. When verification comes, and it will, prepared people move through the system quietly. Unprepared people feel blindsided. And under this new law, preparation is no longer optional. It's part of maintaining your status. So let's get very practical, because this is where preparation turns into protection. If you hold a green card, there are specific things you should complete before January 30th. Not because someone is about to knock on your door, but because the system is changing how it evaluates readiness. The first thing you should do is verify that your address on file with USCIS is accurate. Right now, many people move, update their driver's license, update their bank, update their employer, and forget USCIS entirely. Under the new system, mismatched addresses across government databases are one of the fastest ways to trigger a review. If your address isn't current, update it immediately. Second, gather copies of every U.S. tax return you filed since becoming a permanent resident. If there are years you didn't file because you lived abroad temporarily or believed you weren't required to, this is the time to speak with a tax professional. Under the new law, tax compliance isn't just a financial issue, it's an immigration one. Third, document your travel history. You don't need anything fancy. A simple list of departure and return dates, destinations, and reasons for travel is enough as long as it's accurate. Fourth, collect proof of your ties to the United States, leases, mortgage statements, utility bills, vehicle registrations, insurance policies, employment verification letters, school records for children, and bank statements all help establish continuity. And finally, if you have close family members who are U.S. citizens or permanent residents, keep documentation of those relationships easily accessible. None of this changes your status. It simply ensures that when verification happens, you're ready. The people who struggle under this system are not usually the ones who violated the law. They're the ones who didn't realize they would be asked to prove compliance retroactively. Now, let's shift to H1B visa holders because the changes here are different in nature but just as serious. If you work in the United States on an H1B visa, this new law fundamentally changes the role your employer plays in maintaining your status. Under the old system, employers were required to file certain documents and keep certain records, but enforcement was inconsistent. Many companies went years without being checked. Job duties evolved, work locations shifted, salaries changed. As long as no one audited the case, those discrepancies often stayed invisible. That era is over. The new law creates a centralized employment-based visa compliance registry. Every employer sponsoring H-1B workers must now submit quarterly verification reports confirming that each sponsored employee is still working in the position described in their petition, at the approved location, and at or above the required wage. Quarterly means every 3 months. That's 4 formal checkpoints every year. Here's why that matters so much. Under the old system, problems often didn't surface until you applied for an extension, a transfer, or a green card. You might work for years not knowing your employer made a mistake that could jeopardize your status. Under the new system, discrepancies surface fast. If an employer fails to submit reports, submits incorrect information, or reveals inconsistencies, the employee's status is flagged automatically. And this is where the law introduces something that has immigration attorneys especially concerned, a status contingency provision. This provision allows for temporary suspension of work authorization if an employer is found to be out of compliance while issues are being resolved. That doesn't mean deportation. It doesn't mean your visa is canceled, but it does mean you could be forced to stop working through no fault of your own. For people whose legal status depends on active employment, even a short suspension can be destabilizing. So, what should H-1B holders be doing right now? The most important step is communication. You need to speak with your employer's HR department or immigration counsel and confirm they are aware of the new quarterly reporting requirements. Ask what information they will need from you and how they plan to track compliance. If your employer seems unaware or dismissive, that's a warning sign, not something to ignore. Next, review your own paperwork. Look at your approval notice and labor condition application. Compare the job title, duties, location, and salary listed to what you're actually doing today. If there are material differences, those differences may require an amended petition. Filing an amendment proactively is far safer than waiting for a discrepancy to be flagged. And finally, if you're eligible to begin a green card process or explore alternative pathways, now is the time to start those conversations. This law doesn't mean H-1B holders are unsafe. It means dependence on employer compliance is no longer something you can afford to take for granted. Now, let's talk about DACA because while this law does not eliminate the program, it changes how fragile timing mistakes have become. I want to start with the reassurance first because there's a lot of unnecessary fear circulating. This law does not cancel DACA. It does not revoke protections automatically, and it does not create new removal pathways for people who are otherwise eligible. The core protections remain in place. But, and this is the part that matters, it makes the renewal process stricter, more documentation heavy, and far less forgiving of delays. Under the new law, DACA renewals now require what's called enhanced status verification. In practical terms, that means more proof, more frequent checks, and less margin for error. Renewals will now require updated evidence of continuous residence in the United States, updated proof of education or employment, updated background checks, and biometric resubmission every single renewal cycle, not just the first time. That alone will increase processing times, especially during the transition period when the system is adjusting. But the most critical change for DACA recipients is the renewal window itself. Under the old rules, you could submit a renewal up to 150 days before your status expired. That flexibility gave people breathing room if processing slowed down or documents took longer to gather. Under the new law, that window shrinks to 120 days. 30 days might not sound like much, but in immigration timelines, it's huge. And here's the part that makes this dangerous. The law clearly states that if your DACA status expires even by a single day, you cannot simply renew under the existing framework. An expired status is treated as a break, and reapplying as an initial applicant is not currently available. That means timing is no longer just important, it's everything. Let me make this concrete. Imagine someone named Anna whose DACA status expires on April 15th. Under the old rules, she could have comfortably submitted her renewal in late fall and still had room for processing delays. Under the new rules, Anna must submit within the 120-day window, which means her effective deadline is now mid-December. If she waits too long and submits outside that window, her application may still be accepted. But if processing delays push approval past her expiration date, she faces a gap in work authorization. And if she lets the status expire before submitting at all, she's in a situation that is extremely difficult to fix. This is why January 30th matters so much for DACA recipients. That's when the new renewal window officially takes effect. If your DACA expires at any point in 2025, you need to calculate your new deadline now, not later. Do not assume the old timeline applies. It doesn't. The safest approach for DACA recipients moving forward is early action. Gather documentation well in advance. Track your expiration date carefully. Submit as early as the law allows, not as late as you think you can get away with. This law doesn't punish people who comply, but it gives no grace to people who miss deadlines, even unintentionally. Preparation is the only buffer left. When you step back and look at everything together, green card holders, H1B workers, and DACA recipients, the pattern becomes clear. This law marks the end of passive immigration compliance. The system no longer assumes everything is fine unless there's a problem. It now expects you to be ready to prove compliance at any time. That doesn't mean the system is hostile. It means it's structured. Organized people move through it quietly. Unorganized people feel blindsided. The biggest risk right now isn't the law itself. It's people who don't realize the rules have changed until the system starts asking questions. So, let me bring all of this together in a way that's clear and actionable, because information only helps if you know what to do with it. The Immigration Status Verification and Accountability Act of 2025 is now law. It is signed, it is active, and the first meaningful shift begins before January 30th. If you are a green card holder, the message is simple but serious. Prepare now. Make sure your address with USCIS is correct. Organize your tax returns. Document your travel. Keep proof of your ties to the United States in one place. The verification system may not fully launch until later, but the expectation that you can prove compliance begins immediately. If you are prepared, verification becomes a formality. If you are not, it becomes a source of stress you could have avoided. If you are on an H1B visa, understand that your status is now more closely tied to your employer's accuracy than ever before. Speak with your HR department. Confirm they are ready for quarterly reporting. Review your own petition details and address discrepancies early, not after they're flagged. And if you have the option to pursue longer-term stability through a green card or another pathway, don't delay those conversations. This system doesn't punish compliance, but it exposes complacency. If you are a DACA recipient, timing is now your greatest responsibility. The renewal window is shorter. The documentation requirements are heavier, and there is no forgiveness for expired status. Calculate your deadline now. Submit early, build in margin for delays. The people who stay protected under this system will be the ones who respect the calendar and treat renewals as non-negotiable priorities. Across all three groups, the underlying shift is the same. Immigration compliance is no longer passive. It's active, it's ongoing, and it rewards people who stay organized and informed. I want to leave you with this because it's the most important takeaway of all. This law is not designed to remove people who are living real compliant lives in the United States. It is designed to remove uncertainty from the system. That can feel uncomfortable, especially if you've relied on silence as reassurance in the past. But silence is no longer the signal it once was. Preparation is the safest position you can be in right now is not fear. It's readiness. Know your status, know your documents, know your deadlines, and don't assume that yesterday's rules still protect you tomorrow. I'll continue following how this law is implemented and sharing updates as USCIS and DHS release more guidance because clarity matters in moments like this. If you know someone with a green card, an H1B visa, or DACA protection, make sure they're aware these changes are real and already in motion. The biggest risk right now isn't enforcement, it's ignorance. Stay informed, stay prepared, and most importantly, don't wait until the system asks you to explain yourself before you get